Sharifa, for that lovely introduction, and thank you even more for this introduction, to this invitation to give the Black History Month lecture. It's just a real honour and a great pleasure for me to be here. I have long admired Warwick Law School, and it is just a great pleasure to be here. I'd also like to thank my dear friend and colleague, Dr. Serena Natili, for suggesting me for this lecture. I'd like to thank Sandra Phillips for her amazing, quietly efficient support for me in getting everything in place, all the logistics in place, and to thank Emma for taking time out of, Emma Austin, for taking time out of a busy schedule to engage with my paper, and to thank all of you for coming tonight. And I hope that you'll find at least some of this of some interest. So, the title doesn't really matter, but what I'm interested in is the exclusionary tendencies of the common law and the implications that has for racial injustice and trying to combat racial injustice and racial inequality. So the broad question I'd like to think about is, what role does private law in the form of contract law, consumer law to do with the market, play in responding to racism, discrimination, and inequality? Now, it's very easy for those of us here who are lawyers, who have something to do with law, to kind of think about law in a heroic way. Law is hero. Law comes out to combat these bad things. Yes, we know there are actors responsible for the administration of law, such as the police, who often do bad things, but law is, they shouldn't be doing those bad things, and law is part of what tells us they're bad things. What we think of law as doing when it comes to racial exclusion, racial injustice, it's very typical to look to the human rights model and to say, law is our hero, it takes us away from, it solves those sorts of problems. This case and the story I want to tell tonight asks us to think about law, or suggests we might think about law in different ways. There are all sorts of roles that law can play, and they're not all heroic. Often law can play a more contradictory, a more complex, or even more sinister role in the struggle for racial justice. And that's what I'd like to explore as through the vehicle of a case about a notorious racist incident about 80 years ago that was litigated, that was responded to in a case called Constantine against the Imperial Hotels. So as I said, the incident occurred about 80 years ago, 1943. But this case, and for those of you who are law students or law academics, will probably be aware, because you don't know much about this case, that this case does not feature prominently in English legal education. I think it's beginning to appear as partly through the decolonization initiatives that are going on, but certainly people of my age would not have encountered it in their legal education. And one of the things we need to ask ourselves is, why is that? And I think part of the reason for it is tied up in the problem of the case itself. Okay, so before I get into the talk, the lecture, may I just alert you that the talk does concern racist exclusion and manifestations of bigotry in this country during the first half of the 20th century. I have taken out the worst of the racist terminology that was used, but the scenarios are ugly, and many of the contemporaneous accounts do use patronizing or otherwise offensive language about Black people. But I do think it's important that we do talk about these things. And one of the problems I think we have with the law is that for too long we don't talk about these things. So, okay. So let me just first outline my argument, because there's quite a lot here. So this case, and I'm going to talk about it in a minute, ostensibly the case is a win for racial dignity. That is to say, Mr. Constantine, he was then Mr. Constantine, he subsequently became Sir and then Lord, first Black man to be ennobled in the House of Lords in this country, won on paper in this case. But I think we need to interrogate the decision and the outcome more closely. And I think when we do interrogate it, we will see something a bit perverse. And one of the things we'll see is that the official report on the case essentially erases from view the elemental fact that this case was brought to challenge entrenched practices of systemic racial discrimination in British cities. practices that denied black people and other people of colour access to hotel accommodation, to housing, to employment, to all sorts of consumer markets. The case erases this fact because, not because it does something odd for law, for the common law, it actually does something utterly typical of the common law. That is to say, it adopts the typical methodological technique of suppressing information about the parties, contextual information. We don't know about the consumers' identities. We don't know about the social and political context of the disputed transaction. So to be honest, if you just read the official report in the King's Bench, you would have little idea that the plaintiff was denied service for racist reasons. Fortunately, in this case, for our purposes and for helping us to think it through, there is a huge amount of contemporaneous commentary on the case, especially in newspapers, also in Parliament, on the BBC, and in various other sources. And that commentary helps us to understand what is really going on. But then the question remains for us. Everybody knew that this was about what they then called, somewhat euphemistically, the colour bar in British cities, which was fierce and applied a little bit unpredictably, but consistent and persistent. So why doesn't law know this? Why does that not feature in the case? And what are the implications of law not attending to this well-known fact? A second reason, and I think in some ways more pernicious, why the case does little to counteract racism, or indeed I think tends to help to entrench it, is that it fails to tackle a particular and powerful strand of freedom of contract ideology. And that is the strand that equates contractual sovereignty with freedom from contract, and insists that the other fundamental freedoms of contract, the freedom to contract and the freedom to co-create contract terms, are subordinate. That what counts as negative liberty, the freedom from, and that other forms of freedoms just don't matter as much. Now, this ideology poses a very significant barrier to justice, to racial justice, because it fosters market environments in which those who provide goods and services can deny consumers access to them for capricious or discriminatory reasons without paying compensation or being subject to any other form of accountability. And we see these incidents crop up again and again and again, quite recently around homophobic exclusions, but that's not the topic of my talk tonight. So neither of these things were new or novel about the case. They're actually just routine parts of contract and legal discourse. But I think when you read the case, what sort of is frustrating is that these limits of law, established limits, are it seems like this was an opportunity. This case presented a great opportunity to tackle them. Why? Because Mr. Constantine, the person denied access to the hotel of his choice, was a popular celebrity. These days, he would be a sort of probably a B-list celebrity. I mean, you know, everybody knew his name. I'm trying to, maybe Alex Scott, the footballer, maybe Marcus Rashford, something like that, and a household name. And the hotel's refusal to serve him, and more generally racial discrimination across the sector, actually had been condemned in Parliament and in the court of public opinion. For the sort of 10 months leading up to the litigation, this story ran, people knew about it, it was being talked about. The circumstances then were very, very favourable for the court to examine freedom of contract in consumer markets and to evaluate the role it plays in perpetuating exclusionary practices against minorities. But that opportunity was missed. And so the effect is that the remedy found by the judge, and as I said, there is some protection for the notion of dignity, although Mr. Constantine welcomed it and suggested it was somewhat meaningful, it did leave intact the equation of contractual freedom with the power to exclude, and it didn't touch at all this method of just stripping people of all aspects of their identity, who they are, the context of what happened. So let me just talk a little bit about what happened about the case. On the 30th of July, 1943, Learie Constantine, as I said, then a plain Mr, but later knighted and ennobled, he arrived with his family at the Imperial Hotel in Bloomsbury in central London. Those of you who know Bloomsbury probably know the hotel. I don't know what it's called now, but it was the Russell Hotel, the big red hotel. Well, the Imperial was the sister to that. Same architect, Charles Dole, and sat kind of across the square. He'd booked 4 nights accommodation. Now, Mr. Constantine and his family were very familiar with racial discrimination in Britain. They were British residents, British subjects, and he had checked in advance with the Imperial Hotel that they would have no objection to serving coloured people. Those are his words. And he did that specifically because he'd already experienced once in Brighton the embarrassment of being turned away. He was told at the time of booking there'd be no problem whatsoever. He and his family would not be mistreated because of his colour or his race. So he paid the deposit on 2 rooms for himself, his wife, and their daughter. Upon arrival at the hotel, it quickly became evident that they weren't welcome. So first, the family encountered hostility from the woman at the front desk, both in her language and her demeanour. The woman told them that if they had to, they could stay for 1 night, but they couldn't stay for the 4 nights they had booked. Mr. Constantine then demanded to speak to the manager, and in the conversation, reminded of his booking, insisted on the contractual nature of his rights and the hotel's obligations. The manager reiterated that the family could not stay at the Imperial Hotel, ostensibly to avoid upsetting the hundreds of white American troops who were using its facilities. In a slight twist to what one perhaps might have anticipated at this stage, the manager, though, did offer the family rooms at a sister property in the vicinity. Mr. Constantine, though, stood his ground, citing his identity as a British subject in contrast to that of the American troops, as well as his contractual rights. The conflict continued. Eventually, Mr. Constantine's boss, a white man from the Ministry of Labour, arrived, found the family looking very unhappy. He spoke to the woman who, he says, referred to the Constantines using vile racist epithets. After speaking with the woman, the boss suggested that, and realizing she was utterly intransigent, that in the interests of peace and dignity, the family should look at this alternative accommodation and accept it if it was suitable. They followed that suggestion. The family stayed at the Bedford Hotel, just around the corner, still there, owned by the same company as the Imperial, where they were apparently treated very well. So, just another tawdry story of the denial of service, of racial exclusion in British cities. Countless black and brown people of the time experienced that kind of exclusion, that kind of indignity, and they had done in British cities for decades. And some of them included very well-known people such as Paul Robeson, the black American polymath on the left. Rich people, the man in the middle is Robert S. Abbott, who was the founder of the Chicago Defender, which was the highest circulation black newspaper in the world in the 1920s and 30s, and very well-connected ones. The man on the right is Sir Harry Singh Gower, a distinguished jurist, social reformer, and parliamentarian. All of them had been experienced being refused accommodation or service at London hotels during the 1920s and 1930s. Indeed, by the end of the 1930s, the problem was so acute that the Observer newspaper, in preparation, the build-up to the coronation of George VI in 1937, named the problem of the colour bar. You can see in the second column, as regards London's hospitality, there is the problem of the colour bar existing in some hotels and boarding houses. But we can't do anything about it except rely on public opinion to help. And was entreating the British public not to be rude to and exclusionary towards the people from across the what was then the Empire who would be coming to see the coronation in 1937. By the 1940s, Britain needed war workers from across the Empire and from within, and also black people, of course, who lived in Britain, and they also experienced exclusions, racial injustice. Amelia King, who's a black British woman, was refused work going out to work as a land girl as part of the wartime production of food. And the other picture is Mr. Constantine in the front row in the white suit with that some of the West Indian workers he supported in Liverpool, they were workers who came here to support the British war effort. And there's just a tedious number of stories of people being excluded from. I mean, here we're not talking about the sort of racist epithets and the micro and not so microaggressions. We're just talking about not being, given service in restaurants, in hotels, in dance halls, in basic leisure areas. Okay, so Mr. Constantine, partly from his own experience as being a cricketer working at Nelson in Lancashire, which he had done from the late 1920s until essentially 1939. He played in the last first-class match to be played in Britain before the war. And then he took work as a social worker for West Indians to support them, West Indian migrants, and supporting work effort. And he received a lot of their stories of their experiences. So he decided to deploy his considerable social and political capital that he had amassed as a celebrity, a famous sporting figure, a national treasure, if you like, to challenge the racism that people were experiencing. So it was quite a campaign. It started with publicity. So this event occurred on the 30th of July. He was interviewed on the BBC on 3rd of September 1943. And during that interview, he talked about the frequency of what he then termed personal slights, we'd probably call them today racist microaggressions, that he and his family had experienced since moving to the UK at the end of the 1920s, concluding that, quote, "the daily humiliations hurt and make you bitter if you're not careful." He used the radio interview to spotlight his experiences in England as a professional cricketer and as a social worker to West Indians in Liverpool, and to animate the engagement of advocacy groups in newspapers and in Parliament when he told his story of what had happened to him at the Imperial Hotel. So we get a whole flurry of newspaper articles, of letters to the editor, of advocacy groups mobilizing. We get the parliamentarians asking questions about what went on. This is from the 22nd of September 1943. So essentially, we've got commentators debating British traditions, so-called British traditions of fair play and equality, talking about the pervasiveness of the colour bar, the contradictions of expecting people of colour to support Britain's war effort against the racist ideology of Germany's Nazi party, when the country tolerated and indeed seemed to encourage racial discrimination against them. And there was a lot of criticism, a piece I won't have time to get into here, about British institutions appearing to defer to the wishes of US military personnel, because whilst Britain had refused formally to adopt Jim Crow, the sort of legislative segregation of black American soldiers from white American soldiers, de facto, in some parts of the country, American officers, white officers, essentially put it into place. So this campaign went on this work went on for some time, but eventually it became pretty clear that social sanctions such as parliamentary scolding, reprobation and bad publicity was making very little difference to the everyday practices of hotels, lodging houses, leisure facilities, and so on. And it became fairly evident, as you can see from some of these quotes, I'm not sure if you probably can't read them actually, but anyway, that the government was not about to pass anti-discrimination legislation. So we moved to the litigation. The case was that's a very famous quote, a very famous cartoon by David Lowe, making a mockery of the sort of sanctimonious language and approach of the sort of British rulers, who on the one hand condemned discrimination, but on the other hand pandered to Americans and other the American troops. So the case was tried in front of Norman Burkitt, Justice Burkitt, in June 1944. Constantine had his barrister on his team was Sir Patrick Hastings, who was one of the country's most eminent lawyers, almost by then at the end of his long career, high-profile career. which almost all of which had been spent as a barrister in criminal trial courts. Now, Hastings was incredibly famous. I mean, he had been a Labour politician at one point, but he was really famous. He was one of these flamboyant lawyers who makes a big stir, really, I suppose, it has a big impact in popular affection. And we lived it, the times were a bit different then. And he was known for deadly cross-examination. And he was really known for fact-finding work. He wasn't particularly known to excel in learned argument, scholarly depth, or legal imagination, and that probably wasn't surprising because he had no formal legal education. He'd gone through the apprenticeship model entirely. His second lawyer, Rose Heilbronn, by contrast, had graduated with a first-class degree in law from the University of Liverpool, and she also had a master's degree in law, first woman to realise both achievements. She was still then in the early years of what would become an exceptionally distinguished career as barrister and judge, over which she broke through many glass ceilings and so on and so forth. I mean, it was regarded, this was partly added to the profile of the case, this was regarded as a real dream team. One also describes them as probably the best legal team it was possible to find in wartime. But I think the point I would make is that, like Hastings, Heilbronn was primarily a criminal lawyer, and she was very early in her career. So, again, sort of careful, nuanced engagement with common law theory is not what you would necessarily have expected from these folk. Let's just put it that way. The judge, Norman Burkitt, the man in the middle, was also an extremely prominent figure in the legal profession. Had also spent time in politics. He was a big figure in the Liberal Party. I mean, this blew my mind to read this. In 1935, Daily Express readers had voted him one of the top 20 public personalities they most enjoyed reading about. Can you imagine? I mean, you go from enemies of the people to a judge being one of the top 20 personalities Daily Express readers like reading about. And some of the others included Winston Churchill, Lloyd George, Greta Garbo, Franklin Roosevelt, Mussolini, Gracie Fields, I don't know, and Norman Burkitt, of course, right? What would you expect? Anyway, so for Learie Constantine and almost all of the commentators of the press, this was simply a straightforward dispute about breach of contract. But here we see law beginning to do its thing. It says, well, no, this can't be about breach of contract because in breach of contract, well, the hotel just conceded that anyway, but you can only get nominal damages. You couldn't get anything else. And he wants, recognition of injury to dignity, wants substantial damages, so it has to be about something else. So it was litigated as breach of the hotel's common law duty to receive and lodge a traveller. And there's virtually no understanding in the popular media of that, not that it particularly matters. So what you can see from the days of the hearings as they're reported in the Times Law Report, which gives a lot more information than the official report. So the trial lawyers use it as a platform to showcase their legal skills. They gave the newspapers plenty of sensational copy. Mr. Constantine emerges as a bastion of respectability, a quasi-heroic figure. The judge found he'd carried himself with modesty and dignity, dealt with all questions with intelligence and truth, was not concerned to be vindictive or malicious, but was obviously affected by the indignity and humiliation which had been put upon him, and it occasioned him so much distress and inconvenience which he most naturally resented. The hotel worker, by contrast, the manager, the woman who had dealt with him, quote, cut a lamentable figure and essentially was exposed as a bigot and a liar. So having established the credibility of Mr. Constantine and shredded that of the hotel workers, it was pretty easy to find a breach of the common law duty to receive and lodge the plaintiff. When it came to the remedy, however, they tied themselves in knots and ultimately ended up not awarding the exemplary damages that Mr. Constantine had sought, but in fact, just nominal damages. Which is exactly the same as would have happened under contract. So in effect, although on the liability point, Justice Burkitt found that there were injuries to dignity when the hotel caused Mr. Constantine much unjustifiable humiliation and distress, He decided that the law did not allow him to award substantial compensation for that injury. Instead, he awarded Mr Constantine nominal damages in sum of 5 guineas for violation of a common law right, which is about £150 today. For those of you who are law students, lawyers, a few of you here, you might want to think about that in light of the case 30 years later, Jarvis and Swan Tors, which you may have read as a contract consumer law case, where Mr Jarvis got £125 for getting dry cakes and crisps instead of the fancy cakes and parties he'd been offered. Now that's equivalent to so he got that for loss of enjoyment, and you like loss of the intangible elements of his holiday, and that's about £1,200 compared to today, compared to the £150 that Mr Constantine got. Okay, so the outcome of the case was widely publicised internationally. I mean, it's interesting how much attention this case attracted. So I have found articles that you would expect in Jamaica, in Trinidad. I should have said Mr Constantine was from Trinidad, Australia, Papua New Guinea. A lot of these are India. A lot of these just go out over the wires. But it's interesting the story was reported, and for some, the case marks the point at which English law finally demonstrates a capacity to acknowledge or respond to racial discrimination. But let's just unpack that a bit. Let's start with a very basic question. Is the outcome even a victory for Mr Constantine, which was my very first question? He sought substantial or exemplary damages for injury to dignity because of the hotel's offensive conduct towards him and his family. Much of the legal argument focused on this point, and indeed, the reason why the case wasn't argued in contract, allegedly, was because he wanted substantial damages. But nominal damages is what he got, which is exactly what he would have got in contract, despite the finding of the injury to dignity. So contrary to popular telling of the story, we can see that Mr Constantine did not get what he wanted from law. He did not get substantive recognition of the injury to dignity. Yes, there's a symbolic recognition, but is that really worth the sort of celebration of this as a transformational case? I suppose there's a question of whether the case achieved a different goal that was definitely a priority for Constantine and the other campaigners for change. That is the opening up of hotels and leisure facilities to people who were routinely confronted with systemic exclusion on racist grounds. And that's the claim that those who see it as law as more heroic say this is a breakthrough. This is the first time racial injustice is recognised, and it provides a precedent, a map for others. I think, though, we need to be careful because throughout the case, the more vivid version of the reports that you see in the Times report, we read so much about Mr Constantine being a man of high character. He's a British subject. He's a man of high attainments. And there's a quote which I think reveals far more than the author probably intended, that the Imperial Hotel conceded that Mr Constantine was a man of high character and attainments, a British subject from the West Indies, and that although he was a man of colour, no ground existed on which the defendants were entitled to refuse or lodge him. So it was his respectability that made this such an insult. It wasn't to do with his identity as a black man. So a less respectable black person would have no confidence that the Constantine case would offer them equivalent protection. I am running out of time. There's the obvious point as well that we always make in cases with nominal damages. Yes, the hotel had to pay nominal damages, but it appears just to be, this is a standard concern of consumer cases, a minor tax on doing business that we can't imagine detaining the hotel in any way, especially if we go back to the language of Mr Waldock, the manager for somebody who takes that approach. It's hard to imagine paying a little bit of nominal damages would be much of a deterrent. I'm going to steal 3 minutes of your time. I'm sorry, Emma, but I do want to just get the the freedom of contract point. Because I think the point that most concerns me of this case is its failure to tackle the ways that freedom of contract functions as the foundation of racial exclusion in consumer markets. As I outlined at the beginning, freedom of contract does this work because of the power of the negative liberty idea in the construct that says that freedom from contract has a higher social value than and prevails over other contractual freedoms, prevails in particular over the freedom to contract as well as the freedom to participate in setting contract terms. So what this does, in effect, is give the providers and distributors in consumer markets the power to decide which consumers get access to goods and services. And it means that law denies protections to those who are excluded from access on pernicious grounds such as racial identity, despite their ability to pay. Now, there are theorists, law and economics theorists, who say, well, that's just not going to be a problem because over time, competitive dynamics will emerge in the markets and it will just compete those things out of the way. All the evidence that we see from the 80s and 90s and that we know looking around us tells us that just doesn't happen. Competitive dynamics do not reliably constrain the absolute power of freedom of contract. Indeed, I think one powerful effect of the embedding of freedom from contract into the institutional framework of markets is that contract law then naturalizes and it normalizes, and in those ways it makes invisible it makes invisible the way that contract law itself permits systemic and structural forms of disadvantage such as racial discrimination and market exclusion to be practiced. Instead, what happens is you get the structural work of normalizing exclusion, which is performed by freedom of contract. So those courts and judges who then want to tackle discriminatory and unjust effects of structural disadvantage don't do so directly. Instead, what they do is frame those effects as consequences of the personal characteristics of vulnerable individuals whom the law should assist. And we all have seen those cases, poor old Mr. Bundy, and so on and so forth, right? But Constantine, and one of the things I think is so fantastic about this case, it reveals the utter inadequacy of that framework. Mr. Constantine was not poor. At one point, he was the highest paid sportsman in England. He was not unsophisticated. He was training to be a barrister. He had all the relevant knowledge, experience, and social capital that one could possibly wish for. He was fully aware of the risk of racial bigotry posed to the choices racial bigotry posed to the choices he wanted to make. And he'd sought to manage that risk, to mitigate that risk by checking with the hotel in advance of his trip. Mr. Constantine, furthermore, was backed by the British establishment and he had the court of public opinion on his side. There is not a scintilla of vulnerability in the way that this individual appears before the court. Despite all of these assets, though, of course, Mr. Constantine and his family were not protected against racial exclusion, racist exclusion from the hotel of their choice, and they were inadequately compensated for the injury to their dignity. These consequences occurred not because Mr. Constantine was vulnerable or lacked the skills to function competently in the market, but because the construct of freedom of contract based on the primacy of freedom from contract fails to deliver access to markets for all. So I'll just switch to go to the end then. In sum, I think what we see in this case, this symbolic acknowledgement of the injury of racial discrimination in markets in the UK, and it's good to see that acknowledgement. On the other hand, and in doing that, the case perhaps delivers a marginal gain to Black and other minoritized people. However, the court's lack of engagement with the concepts of freedom of contract means that the case does little to address racial injustice and indignity. Instead, though, analysis of this case in its historical context does expose and remind us of the role of law, private law, contract law, in perpetuating market inequalities. And then I think by implication, the work that must be done to counteract this type of harm in consumer markets. Work that to this day, I think, largely remains to be done. Thank you very much.
quite sure how to follow that, especially as a non-lecturer, you know, as a lawyer. And clearly I'm white, so I don't offer any personal or lived experience of the racial injustice issues that I'm going to talk about. What I'm hoping to bring is the perspective of a civil legal aid practitioner, a social welfare lawyer, who works with, unlike Mr Constantine, poor people. And I hope to bring, you know, my insight and the insights of my colleagues at Central England Law Centre to this issue. Central England Law Centre is the biggest in the country. We represent more people than any other law centre in the country, and we are providing legal aid in a range of civil social justice fields across, you know, almost a full array really of social justice fields. And I'd like to say that things have moved in the 80 years since the Constantine case, but unfortunately what I'm going to tell you is that what I've seen in practice and what my colleagues have seen is everyday injustices, inequality, discrimination against Black people allowed to persist. And it's allowed to persist in part, I think, because the civil legal aid system in which we operate, which is a key component of civil social justice, is broken. It's completely broken. Professor Williams spoke of missed opportunities, both in the justice system and in education. And those themes really resonate with me. And I want to talk to you about some missed opportunities that I see in practice, both in the justice sector and in education, that I think would go a long way to resolve some of the injustices that we see on a daily basis. So just a little bit of context first. Legal aid, civil legal aid now in this country is only available for the poorest, people who are destitute or there or thereabouts, compared to in the 70s when 79% of the population in the UK would have been eligible for civil legal aid, down to about 47% in the 90s. As at 2007, only 27% of the population was eligible for civil legal aid. Since then, significantly less. We don't have the current figure, but significantly less. And what we do know is that 94% of the working poor, for example, would not be eligible for civil legal aid now, based on the financial eligibility criteria. Well, why is that important? Because more Black people live in poverty proportionally than their white counterparts. Central England Law Centre is based here in Coventry and in Birmingham, and we are, according to the latest census, representing people who are living in between the 10 and 20% most deprived areas in the UK. 61% of our clients, 3/5 of our clients, are Black or from minority ethnic backgrounds. Why are they our clients? Why? Well, because they're eligible for legal aid. They're at that point of destitution. They're at that point that they still qualify. And nationally, the figure's even higher, so 72% of legal aid cases nationally are now for people from Black or minority ethnic backgrounds. It's really important in social welfare law that we recognise that, because poor people are more beholden to the decisions of the state than people with money. Poor people are more affected by the actions of powerful private operators where there's a power imbalance than wealthy individuals. A tenant versus a landlord. A tenant has a power imbalance. An employee versus an employer. An employee has a power imbalance. And unfortunately, what we're seeing now in social welfare practice is increasingly poor quality decision-making by public authorities. in the wake of austerity and, cuts to services, gatekeeping of services, we're seeing poor quality decision making and increasingly, at times, unlawful decision making. And we're seeing increasingly unscrupulous behaviour by private actors like landlords, employers, towards individuals, to whom we would expect that they would owe a duty of care. Now, the wealthy can address issues that arise for them by accessing private legal advice. They would pay for a solicitor to help them resolve their legal problems. But when you're poor, you're reliant on civil legal aid. But post-LASPO, the Legal Aid Sentencing and Punishment of Offenders Act in 2012, legal aid isn't effective in helping poor people pursue and enforce their rights any longer. I'm going to talk to you about some of those reasons why. Well, as I say, the word I used was broken, and that's truly how I believe it is at this stage. So firstly, LASPO removed from legal aid scope vital areas of social welfare law that previously would have helped people to tackle issues early. They were preventative, protective areas of social welfare law that prevented problems from becoming crises, preventing problems from snowballing to the stage where they were really complex and where really somebody was as vulnerable as could be. Research has suggested that 25% of legal problems, if people receive early legal help in relation to their social welfare problems, could resolve within 3 to 4 months. Without that early help, problems take in excess of 9 months, and sometimes, a lot in excess of 9 months. By way of an example, a single working mum, so she's working, she's probably amongst our 94% working poor who can't access legal aid, is fired from her job, can't access legal advice post-LASPO and employment to help her, potentially challenge that decision. So she applies for benefits. The DWP unlawfully and wrongly refuse her application. She can't challenge that decision with the help of legal advice, civil legal aid at that stage. She has no money. So ex-partner decides he wants to take the children and he wants them to stay with him instead. No legal advice available for private family law for her. She's reaching a stage of poverty, reaching a stage of debt. No legal advice available to help her overcome that debt. She wants to negotiate with her landlord because she's now struggling to pay her rent. No legal advice to help her do that with legal aid now. So you see, all of these stages at which intervention could have happened to help her are gone from the civil legal aid process. Now that she's at risk of eviction, legal aid's there then, but she's already reached crisis point. Now that the local authority are concerned about the welfare of her children because her ex-partner isn't caring for them adequately and wants to take her children into care, legal advice is available there with civil legal aid. But that's the stage it's had to reach before help is now available. Professor Williams talked about missed opportunities. We've got a missed opportunity here, multiple missed opportunities to resolve problems at a point when she could have had, a life that hasn't spiralled to, a really rather desperate situation. No legal advice means that in many areas of civil welfare removed from scope by LASPO, we now have more litigants in person who have poor legal literacy, often ill-equipped to navigate, complex processes and systems that exist within the civil justice system. Filing documents, serving documents, gathering witness evidence, presenting a case in court. An inability of litigants in person to do this efficiently. And why should litigants in person who are non-lawyers be able to navigate the system? But their failure to do so has resulted in huge court delays, longer times for